everyone again. Welcome to EBC Learning CII Upskill Diploma on Advanced Corporate Law. This is a preview class or a dress rehearsal class on principal-agent relationship in company law by Professor Ruby Panchal. I think by this time, everyone must have figured out how this platform is working. The rationale behind using this particular platform was so that we can have higher interaction and networking around here so that people could connect with each other. Generally, I think a WebEx or a Zoom or a Google Meet fatigue has set in. So we thought it would be fun and interesting way to connect everyone with each other and conduct our classes here so that they are quite highly engaging and interactive. Of course, we would be adding more things as the course would progress, and people who are also part of the course and are willing to join the course would experience it. A lot of gamification will come. A lot of things would be added. So readings and everything would be accessed from here and otherwise from the platform. So let me take this opportunity to introduce to all of you EBC Learning. For those of you who are aware of, I'm quite flattered, but others, please look at the EBC Learning platform. So let me share my screen and you could see. I hope everyone can see my screen now. So this is our platform, EBC Learning, where you could find various self-paced courses and also the live learning courses. So the instructor-led path is the live learning course, which is, as you can see, the EBC Learning CII Upskill Diploma in Advanced Corporate Law. Within this, we have several self-paced courses which are listed. But apart from that, we have many skill-based courses which are there, and some of the courses for competition as well, such as cracking the advocate on record examination. We have arbitration step-by-steps, transacting mergers and acquisitions, handling check bounce cases, RERA essentials, how to create a will, a course on contract drafting, corporate assets valuation, banking essential, a course on due diligence, economics in competition law, etc. Criminology essentials, right? So this is our platform, and you could visit ebclearning.com or ebclearning.com/courses directly to look at the listing of the various self-paced learning courses. All the courses are divided in smaller modules and smaller subunits. And here you could access very informative videos, and you can watch them and learn on your own at your own. And along with them, there are a lot of exercises. Some of them are short answer types, others are MCQ based exercises. And on the completion of these courses, you get a certificate of completion, which will be very helpful for you in your upskilling journey in general. So let me introduce you to now the course on the EBC Learning CII Upskill Diploma course on Advanced Corporate Law. Just give me a second, I'll share a different tab. So this is the EBC Learning CII Upskill Diploma in Advanced Corporate Law tab, which is also present there at various points within the environment. If you want to look that up, the link is also shared in your emails. Otherwise, the link is right there in this environment around at various standees. So you can visit them, press an X, and this will open up for you. And you can visit the place, and you can schedule a call to find out more about us, and any one of us would reach out to you soon. Now, just to introduce the course basic things here, the first one is that we are starting very soon. So there's very limited time available. That means the enrollment stops at 14th April. And it's a 6-month course and would require somewhere around 8 to 10 hours per week of your self-study time. And every class that we are going to organize, almost every class would have a smaller assignment. Some of the assignments would be greater in length, but depending upon the nature of the class, you have to complete the assignments. So the idea behind the assignments here is to develop your learning. This is not a law school. This is not a place where we tuition you to complete your assignment or check up on your homework. The ultimate idea here is the assignments. The ultimate idea behind the assignments here is so that we know that you know things and that you have really gained the skills so that we can award you a diploma in advanced corporate law. Now, if you look at the course in general, we have 2 to 3 live classes in a week, and all of those classes would be generally in the evenings because most of the instructors would be free at that time, and also many of the working professionals would be free. And if you are a student right now, for you as well, it would be a very convenient thing. Along with it, you'll have access to more than 550 plus video content. The video content is there's excellent video quality. It is they are there with some amount of animations, and they are beautifully recorded videos along with the assignments. Apart from that, you will get access to SCC online cases and somewhere around 16 ebooks on EVC Reader platform. That means when you are watching the videos and learning, and if you really want to read up on something and want to access our books, or if you want to access some judgments on SCC online, that would be available to you on a single click. So you just click on them, and the next tab, either the book or the SCC online judgments, will open. So in that sense, it's some sort, all the EBC products are integrated. And so in the learning path, the self-paced modules from our platform that would be available to you would be the law of agency, the contract drafting essentials, right? So let's say if you are attending the class of contract drafting, so it would be very convenient for you to first learn the basic understanding of the contract drafting from this course. And then you could straight away come to the live learning classes where the advanced levels are addressed, and some amount of basics would be covered so that there is a continuity in the class. And then the hands-on training in contract drafting and also in the other modules and parts of the course is provided so that you learn from the experts and you learn by doing things. And that's the real agenda here, right? So similarly, contract law, understanding limited liability partnership, due diligence essentials. So all of these are pre-recorded videos which you would have access to. On top of these pre-recorded videos, you would have access to somewhere around 100 hours of live learning. Each class would be of an hour and a half length, where 1 hour is basically uh, the lecture or discussion or interactive session, and last half an hour we have sort of kept for interactions or networking or your doubts or questions, etc., etc. So these are the self-paced courses. As I'm scrolling through, as you can see, if you can't see my screen, you can click on the button where you can see Pradyumna's screen, so it would come as a full screen. Then economics in competition law, transacting M&A. These are the books, as I have told you, you would have access to these books. The Gather is now you are familiar with. And let me introduce our instructors who would be here. So Dr. Anchal Dua is a part of the EBC. She's a senior consultant here. Abhishek Sharma is a partner with Link Legal, and he'll be taking up the classes from the side of insolvency. Aditya Singh would be taking care of the classes towards the debt finance side of things. Aditya Singh Chandel is a partner at AZBN Partners, and he'll be looking after taxation related inquiries when it comes to mergers and acquisitions. Amrish Garg from Finvox will be taking care of the financial sides of things, because what is really important here is that anytime you're processing a particular transaction, it would have elements from all over. It may have elements from economics, it will have elements from accounts. You need to know, the basic accounting principles. You need to know how you look at a balance sheet or a profit and loss statement, or how do you navigate through the Schedule 2 of the company law, etc., etc. And also at the same time, when you are doing other things, when it comes to insolvency or to the mergers aspect, and there the valuation aspects of things. So we are not saying that will make you an expert in accounting, but as a lawyer or as an in-house counsel lawyer, or if you are working at a bank, or if you are working in one of the law firms, it will be really important for you to know that these are the kind of documents that are going to come to you, and how do you navigate around it. For example, if it's a case of corporate fraud, how would you actually trail and follow the money and understand things. So similarly, so we have Animesh Sinha, Ankit Jain, Arman Patkar will be taking a session on insider trading. Arman has also written a book with EBC, which will also be accessible to all of you. Avinash Sharma would be looking after the competition side of things. So both the compliance aspects of it and also the litigation aspects of things. Badrinath Srinivasan will be taking care of the contract drafting side of things. Dr. Charu Mathur is an integral part of EBC Learning. She's also an advocate on record, and she'll be dealing with some of the introductory classes as well as some of the classes in insolvency. Gandharv Jain and Amrish Garg will be taking care of the financial side of things. Gaurav Priyadarshi would be looking after the debt finance side of affairs. Karishma would be giving a hands-on training on due diligence, whether it is during the IPO process or it is during the M&A. So the things that an A0 or an A1 or anyone perhaps in a law firm would have to do day in and day out is due diligence. So these are the exercises that she'll be taking care of. Ketan Makhija was also a partner at Link Legal, and he'll be taking care of some of the classes in the capital market sides. He'll be demonstrating you how and what are the important aspects and things in DRHP needs to be taken care of. What are the roles and responsibilities of different lawyers, whether it is from the law firm or from the company which has approached the law firm, or even from the sides of the underwriters or the bankers, etc. Nilanjan will be taking classes, the very discussion-based classes on pre-incorporation of contract, and a very important class on corporate fraud, where we'll have like a big assignment so that you could actually see, look, and understand the nitty-gritties of how to detect a corporate fraud, and also the forensic audit aspects in the corporate fraud. How do you get the red flags in place, etc. So Paras is also part of the FinVox. I'll be sort of introducing the corporate legal methods. Dr. Pratima is also here. She will be taking some of the introductory and inaugural classes, where a firm base to the corporate law would be provided by her, and a later class on looking at the meetings and the director's duty. We are here present in the class of Professor Ruby. Sukriti will be taking a class related to promoters, their responsibilities, roles, and duties, and how things have changed recently. And Tarun Mathur is really an expert in M&A. He also has a book with EBC. So a major area would be looking at the transaction process in mergers and acquisition. So at the end, when you are attending this course, all of this would tie in together when you're doing the M&A process, because in a life cycle of a transaction, you would be able to see all the elements that have been discussed before, whether it is the insolvency aspects, looking at the target company, or whether we are looking at the merger control aspect, where the elements of competition law is involved. Victor Nayak would be taking some of the inaugural classes, as well as an important class on incorporation of company, or changing one company into another form of company. So what are the important checklists, and how do you actually go about doing it on going on the MCA website? and a mock exercises, beautifully curated mock exercises on actually registering a new company. Yugang Goel would be taking care of the competition economics, because it's really important before you actually go to learn competition law. You need to really understand the economics behind the competition. So as I said it before, the course is quite comprehensive in nature. It is quite a rigorous course. That means all the elements that surrounds corporate law we have covered, whether it is learning the economics angle of it, or the learning of basic financial literacy, or looking around how you access through the balance sheets and etc. At the end of the course, you'll also get a certificate and a personalized recommendation letter based on the kind of exercises that you have done and how you have performed and where you had your more interest in. So a personalized recommendation letter and a certificate by EBC Learning and CII. And we have these internships and placement partners where you could always apply for your internships or for your job prospects. Yeah, so at the end, please access this link. This all of the informations I've gone through here. But please feel free to reach out even after the session if someone wants to hang around. I will be here for some time. If you have any doubts, any questions regarding it. But one thing is I can assure you that this course is also going to be quite fun, and it's going to be quite challenging, and anyone and everyone who is looking up for a new challenge and a lot of learning and a comprehensive learning are most welcome to join. Although we have a limited seats, so I would request people to reserve their seats as early as possible. Right now, without much ado, I'd like to hand over uh, the microphone or the spotlight here to Professor Ruby Panchal, and you could all attend her classes. Just again, in terms of the housekeeping rules, if you have any questions to ask to Professor Ruby, you could raise your hand. If you could see in the bottom tab where your name is there, you could see your smiley face, so you can raise your hand. Uh, and and if you want to interact with the professor, you can always go to the spotlight buttons, which is present in the middle. If you can see, there are two blue loudspeaker signs. So if you walk your character with the help of the keyboard or a triple click from your mouse,
Hello.
you
Hi,
will interact.
Pradyum. I think maybe you can share your screen, and then people would be able to follow much better in terms of the location
Right.
for where these raising of hands facility and the spotlight
Right.
facility.
Sure. I hope everyone can see my screen, and if it is coming as a small tab in the corner, you can always click on it and it would expand. The same goes for the video feed of Professor Ruby Panchal, and also when she is sharing her screen for the PPT. So if you can all see me, I can walk around and pass through this classroom. So if you can see this blue mark here, so if you keep your cursor here, you automatically go on spotlight, and then everyone will be able to hear you. Of course, you have to unmute yourself to interact with the professor, and so that your question is heard by everyone. And similarly, we have kept another one here, if you can see, and then you can, once you are on the spotlight, everyone can hear you, and your voice would reach the professor, and everyone can hear your doubt or question, and she would clarify after that. In case of any other questions throughout the session, if you think that are not addressed, you can simply write a message in the chat box, if you can see here in the corner. So these are the people who are online. You can click on this Pradyumna, or let's say I'm doing it with Abhinandan, you can type your message here and put an enter. I'll get the message. If you want to follow anyone, you could just simply follow. You simply follow that person wherever that person is going. So that is all about it. Now, I hope everyone has taken their seat, and I've exceeded my time by 2 minutes. So if Professor Ruby is ready, I'd request her to take the spotlight, and I will get out from the spotlight and attend the class like everyone else here.
Hello. Am I in the spotlight now? Just to confirm.
Yes, Ruby, you are in the
All
spot.
right. Perfect. Hello, everyone, and welcome to this platform. To those of us who are joining us here, I would be taking a short class on the topic called principal agency relationships in a company. Let me just quickly share my screen. Just like to introduce myself very briefly. My name is Ruby Panchal, and I've been teaching as assistant professor at Jindal Global Law School since past 3 years. And before that, I was practicing for a couple of years, and I majorly practiced commercial arbitration. So, guys, today we'll be looking at the topic called principal-agent relationships in a company. And I hope all of you can see the screen that I've shared.
Yes, we can. The screen is shared. We can see the screen.
All right, perfect. So, guys, I like my classes to be very interactive. So I would keep asking questions from you guys throughout my class. And if you feel like you have any question to raise or any comment or any opinion is coming to your mind, just feel free to go to the podium as Pradyuman explained to you guys and speak your queries, right? You can also put your questions in the chat box, and I will make sure that I see the chat box from time to time to look at what opinions you have put forth there. So today we'll be discussing principal-agent relationships in a company. Before we delve into how this agency relationship is seen in the company, how we can identify these relationships in a corporate structure, I have a general question to ask all of you. And feel free to come up to the podium and answer whatever you know about this. How can we define a principal-agent relationship? So when we talk about this relationship generally in terms of law, what is it that comes to your mind? So when can we say that two people are in a principal-agent relationship? One is acting in the capacity of a principal and the other one is acting in capacity of an agent. All right, so I'll answer this question for you guys. So to define principal agent simply, I think the first thing that should come to our mind is that agent is carrying certain tasks on behalf of the principal. And principal is the person here who has delegated his actions to the agent, right? Now the one thing that comes up here is that principal has delegated his actions to the agent, and it is agent who is performing those tasks, right? So the point to be noted here is it's the agent who is carrying the tasks of a principal on behalf of the principal. And two contentious things that comes out of this relationship often is whether the principal has given the authority to the agent to conduct a certain task. So pardon my handwriting here. So first contentious matter that often comes up is the matter of authority. And secondly, the second question that often comes up here is the matter of liability. So when your agent is carrying out the tasks of the principal and any liability is incurred therein, who bears the burden of that liability? Is it the agent or is it the principal, right? And whenever agent is carrying out any tasks, the question that often comes up is whether that agent is authorized to carry that task at all, right? And can any one of you tell me why agent would move beyond his authority at times and why the question of liability comes up? So if generally agent is carrying out tasks of a principal and a liability is incurred, the logic says that because those tasks are being carried on behalf of the principal, the liability should also be that of a principal. But why do these contentious matters arise? Can anybody of you think about a possible scenario? I think we have certain comments in the chat box. Let me move there. Mistakes by agent. Absolutely correct. And in that case, if agent is carrying out task of a principal and any liability is incurred, principal can say, well, hey, I'm not going to incur that liability that you incurred because it was your mistake. Either you did something which was out of the authority, I did not delegate that to you in the first place, or secondly, whatever liability you incurred, it's not within the course of our agency relationship. It was due to your personal mistakes, right? It was beyond the extent of authority which I have delegated to you. And the same, and what could be the possible underlying rationale of this? The possible underlying rationale could be that agent constantly faces something that we can term as conflict of interest. Right? So whenever principal-agent relationship is formed, an agent is out there carrying out functions on behalf of the principal, there is a dilemma which is faced by the agent constantly, whether he or she should perform for the better interest of the principal. So whether maximization of principal's profit should be the agent's aim, or whether to act in their own interest should be the agent's aim. Right? So there is a constant dilemma that every agent faces. Should I work in my own benefit or should I work in my principal's benefit? So when we transplant this relationship onto a corporate structure, now before we transplant this onto a corporate structure, we see three prong structure which comes up when we talk about principal-agent relationship. So firstly, whenever this relationship is formed, you have a principal and an agent in the picture, right? And as we discussed, your agent is constantly facing the conflict of interest, right? So there might be instances where agent is acting beyond authority, agent is acting in their own interest, and agent is acting contrary to the interest of the principal. And this is precisely what is termed as agency problem. Right? When agent is not working towards the benefit and welfare and profit maximization of the principal, rather is working for itself. And principal here, of course, has to put in a proper check and balance system in order to make sure that the agent is behaving properly, that agent is carrying out their tasks properly. And how does principal do that? They can do that by two meanings. Firstly, they can enforce in a private mechanism, and secondly, they can take help of whatever law is existing there to keep an eye on agent's relationship, right? We will study all these three criteria in context of a corporate structure in this class. So today, since we have only 1 hour, we will only try to establish we will try to identify what kind of agency relationships persist or are there in a company. So whenever we talk about company and principal and agent, we see two kinds of principal-agent relationships, right? I hope all of you appreciate the fact that the most basic principal and agency relationship comes out of a contractual relationship. So there needs to be an express or implied authority given by the principal to their agents. And that's how principal and agent can come into an agency relationship, right? So that's the most basic type of relationship, which I think you would have already studied. Another kind of relationship which we identify in the company is the analogical one, right? Now, these kind of relationships do not have a contract of principal and agent in the strictest sense. We are only uprooting this theory of principal and agent and putting it on certain players of company, and we are trying to establish that kind of relationship between them. Now, why are we doing that? We are doing that in order to identify the problems that can come between these players, and in order to define the agency costs and the agency solutions that can be instilled, right? And this is exactly what our class would be focused on today. We will together try and identify 3 analogical principal-agent relationships. So before moving on with the first one, there is a study. So the study was actually carried out in 1932, and it was carried out by 2 legal scholars, Burley and Means. Right? Before I discuss the study of these 2 legal scholars, I have a question, again, a question to ask all of you. So whenever we think about a company, right, and we would know, and we would also study in this course as to how company is a separate legal entity. But if we have to pinpoint certain owners of a company, who do you think we would point towards? So if we want to identify who is the owner, rightful owner of a company, so which player in a company do you think should be termed as owner of the company? And think about it in these terms. Who deserves the profits of the company, firstly? And secondly, who deserves the residual money which is left, or the residual assets which are left whenever a company is liquidated? Let me go to the chat box real quick, because I think we have certain comments there. All right, Harsh and Pratima, you guys pointed out how agent does face a conflict of interest. And whenever agent acts out of authority, that causes a problem and forms a contentious issue between the two. That's absolutely correct. Sarup says that shareholders would be the real owner of the company. Can we have an explanation from anybody as to why it's the shareholders who should be called as owners of the company and not maybe directors? Why can't we term directors as owners of the company? And why is it that shareholders are the ones who deserves to be called the owners? So I think I did try to answer that question myself in the beginning. Let's see, we have a comment there. Shareholders, they fund the company to do the business. Absolutely correct. So they are the ones who are bringing in the investment in the company in the first place in terms of the share capital. Also, they are the ones who are entitled to the profits of the company. And also, they are the ones who are entitled at the end of the liquidation chart, when the company is wound up, they are the ones who gets to have their hands on the whatever assets and cash which is left with the company. So shareholders are rightfully can be ascertained as owners of the company. Right now, of course, shareholders would be the owners in when we talk about company limited by shares. We also have company limited by guarantee and unlimited company. So in all these 3 companies, it's the shareholders, the guarantor, the owner, who is the rightful proprietor of the company. All right, so in 1932, coming back to our study, in 1932, Burley and Means, 2 legal scholars, they conducted a study on the American company structure, and they find out something very interesting. They find out that the shareholding in American companies is very scattered. Meaning, they found out that if we have 100% of the shareholding, we do not have a majority shareholding in name of certain individuals or companies. The maximum concentrated shareholding that an individual or a company has is between 10 to 15%, which gives them enough leverage to have certain kind of hold over the resolutions which are passed in the company. But beyond that, they found out that they've studied all the major companies, and mind you, they studied all the major public companies whose shares are already out there being listed at the stock exchange, and they studied that we do not find a concentrated shareholding. There's no particular individual or company having more than 50% of shareholding in those companies. They have a concentrated shareholding between 10 to 15%. And what about the rest of the shareholding? approximately 85 to 90% of the shareholding is scattered. Right? And what do we mean by scattered? They have a very teeny tiny small share in the shares of the company, which is as tiny as less than 1%. And what does that result in? These scattered shareholders, they do not have any aptitude or interest in the affairs of the company. Right? So we started this conversation by ascertaining that it's the shareholders who are the owners. So they should be the one who should have interest in the affairs of the company. And now after Burley and Means study, they found out that, well, most of the American companies having scattered shareholding. A person with less than 1% shareholding in a company like Apple Inc. would have nothing to do with what kind of decisions Apple Inc. is taking, right? So Burley and Means concluded that this has led to a division in control and management of the American companies. Meaning you have ownership. So let me write this again. Sorry for that. Right. So we have ownership on one hand and we have control and management on the other. Right. So Burley and Means said that ownership, of course, lies with the shareholders. And since they're all scattered, they don't have any significant shareholding. They're not concerned with the affairs of the company. And who is concerned with the affairs of the company? That duty has been rightfully delegated to the management, to the board of directors. Right. So what we see in American companies is a difference between ownership and control and management. Right. Now, I would just like to give a disclaimer here that this study was in 1932. And recently, of course, there are studies in US which says that this pattern is changing. But let's focus on this differentiation of ownership and control and management. I have a case to discuss with all of you. And after that, I would like to hear from all of you if you could identify a principal and an agent relationship between the two. Right? So remember, these are analogical relationships. There's no express contract of agency here. What we have to see is principal is the one whose interests are being looked over by another person, right? And you have to see, you have to identify principal agent relationship from that perspective, right? Whose interests are being carried forward by whom, right? So our case study really started in 1985 when two oil companies, they merged together and they formed a company called Enron. Right now, at that time, I think his name was Mr. Ken Lay. So Mr. Ken Lay was the CEO of Enron. And they got on board this very ambitious fellow, and his name was Jeff Skilling. So he started with this company as a mere consultant, and later on, in the early 2000s, he also became CEO of Enron. And he introduced several new ideas to the company. So Enron was initially just an energy company, but they diversified and they tried to diversify and expand their business into trading of energy, into pipeline sector, into paper sector, and most interestingly, into the broadband sector, which was booming in America at that time. So Enron was diversifying, right? And of course, I hope you guys appreciate that whenever a company diversifies, it requires a lot of investment on part of the company, right? And it does take some time for a company who's diversifying to establish itself in that sector and then to actually reap profits. So Enron was diversifying. They also opened up their subsidiaries in this part of the world, in India, in Philippines, in Indonesia. So Enron was really trying to expand its business. And one thing that everybody was noticing was that Enron's profits were constantly booming. So Enron was constantly in surplus, right? And one thing that happened with Enron was that share price also was increasing at a really fast pace, right? Now, there were several factors as to why their share price was increasing. One of the factors was their accounting technique, which they approved of. So they adopted a technique which was, of course, approved by the US security organization as well. This technique is called market to marked price. And what you really get in this technique was you can value your asset in today's date in terms of the surplus you think your asset is going to generate in the future, right? So let's say I own a factory today, and then I ascertain that, all right, 2 months later, my factory is going to make me a profit of, let's say, 5 million rupees per annum. And then I can value my asset at that price, right? So it sounds ridiculous, and of course you can use this accounting technique to your advantage. So they were using that technique. What Mr. Lay and Skilling did was they also created a hype. They also built what we call a bubble with the name Enron, that Enron is diversifying. We are going to reap endless profits. Our shareholders are going to benefit immensely. And they created that image, which led again to increase in share price. And what Enron was actually doing was, one would think that, all right, if they're manipulating their books of account, if they're inflating their share price, that's all right. But where is Enron actually getting its cash from? So what Enron would do, guys, is, of course, they inflated their share price, and they would sell this inflated share to their special purpose vehicle that they create, right? They would create companies, the SPVs, the special purpose vehicle. They would they would sell their inflated share to these SPVs. And in return, the SPV would give them cash. Right? Now you would think those SPVs are, of course, created by Enron itself. Where are they getting cash from? So now these SPVs would go to American banks, and they would pledge these inflated shares with these banks, right? So pledge is loaning out a movable asset. They would pledge these inflated shares with these American banks. Of course, the banks were also under the perception of the great image Enron is having. The bank would take that pledge, would give the cash to the SPV, and in the end, SPV would transfer that cash to Enron. And this is how Enron was really surviving, right? There was a lot of manipulation in the books, and they carried on like this for years, right? Until 2001, when their own vice president, and her name is Sharon Watkins, she recognized all these wrongdoings in the company, and then she finally blew the whistle, right? And when this happened, so this was the result on the shares of Enron. So within a matter of months, the share price came from $90 to 0.67 cents. Right? Now I would like to listen to your comments. Who do you think is at fault here? And if we want to establish a principal-agent relationship here, so is there any party in this question who was entrusting their benefit or their beneficial interest onto the hands of others? So who are those parties, and who is really at fault here? Feel free to speak up or write your comments in the chat box. Let me quickly go to the chat box to see if you guys have any comments to make. Yes, please go ahead.
Can you hear me?
Yes, we can hear you.
One way to look at is if we consider the CEO and the other executives as agent of the corporation or the company. That is one way to look at. The agent has made a mistake here, so the principal has to face the consequences because CEO becomes an agent in this kind of a context. So though agent has made the mistake or has ulterior motive, because of that, principal, which is the company, went down the tube.
Right. So we have one opinion, and you said that, all right, here we think that it's the principal. Let me magnify this. The company would be the principal, right? And the directors, the CEOs, and all the other managers and the directors who were involved in this, let me just categorize them as the management. They are the agents here. Right? Now, of course, if we see company as a principal, that's also a good way to look at it. In fact, we will study the relationship between company and its director when we study about actual principal agency relationships in a company, right? Because there has to be a contract between a company and the director, right? A contract forming a principal agent relationship. But if we try to make an analogy out of this, so whose interests are really at stake here? So when the share price of Enron in 2001 fell from $90 to 0.67 cent, which is the party which actually suffered here because of this?
It's the shareholders ultimately lost their.
Absolutely. So it's the shareholders, and we have similar comments in the chat box as well. Sarup says that higher management would be our agents. Enron is principal and SPV is the agent. Shraddha, that is a very interesting relationship that you've identified there. And in that particular transaction, yes. But if we see at Enron as the overall wrongdoings in the Enron, then we need to highlight the bigger principal and agent here. Ankita says shareholders. I think you are suggesting towards the principal. That's absolutely correct. The investors, the shareholders. Yes, that's correct. Let me quickly go back to my PPT. All right. And why do you think, guys, this conflict arises? So shareholders rightfully invested in the company, and they asked the management to look after the affairs of the company. But what came in between? The management's conflict of interest came in the between, right? Management really has to think about, should we be satisfied with the salary or the retainership fee that we are getting from the company, or should we take certain actions and fill in our pockets deep, right? So management here as agent face that conflict of interest. Should I really work in the favor of the company towards maximizing profit surplus of the company so that shareholders can reap in the profit? Or should I work for myself and try to fill in my pockets deep, right? So that's the first agency problem, that analogical agency problem that we have figured out, which is owners, shareholders versus the management. Right? Now remember, in today's class, we are only identifying who are these principals and agents. In the second leg of this class, we will identify what can be done to rectify this, right? So what kind of mechanism should be in place just to make sure that another Enron scam does not happen, right? A similar scam to Enron, which was unraveled in India, was the Satyam scam. Right? Again, there was a differentiation between the ownership and the management. And finally, some of the foreign shareholders, they tried to figure out what was really going on in the Satyam company, right? So we will discuss that in the second leg of this class. What are the remedies? What should be the agency systems should be in place to protect this? Let me see. I think there are a few comments in the chat box. Let me quickly go there. So we have a comment in the larger sense. Can we say that employees are the agents of the company? Greed of management. Absolutely, we can say that. And that's actually one of the principal agent relationship which we'll study, right? So stay tuned for that. So we'll come to this relationship as well. Shareholders are not, so in that employees would actually not be the agents. We have to figure out if employee is the one who's going out and doing the wrong deeds, of course, then employee is the agent. But if employee is being wronged itself, then also we have to figure out who's agent and principal there. Shareholders are not concerned about the internal affairs of the company. That is the reason for management mistakes. Yes, and that is the underlying rationale of this first agency problem that we see. Ankita says the accounting technique of the company. Of course, so the management was the one who was fudging everything. And in Enron, guys, we see the big four now. At that time, we used to have something called Big Five, and there was a company called Anderson, and they were a huge accounting company. And after Enron case happened, so of course, Anderson company was being bribed by the Enron management, and they were helping them in fudging and in miscalculating the books of accounts. So after Enron scam happened, the US government banned Anderson from doing any kind of business with the public companies. And Anderson only had public companies as the client, so that company came down real quick, right? Now, the first problem is owners and shareholders versus management, and we really get this agency problem out of the Burley and Means study. While Burley and Means talk about scattered shareholding that is there in the companies, Professor Umakant, now again, he's a very well-renowned professor in terms of company law, teaches at NUS, National University of Singapore. He's conducted a study in the 80s, and he conducted a research on patterns of the Indian company, right? So he said Burley and Means did the research on the American companies and identified that most of the shareholding is scattered. What about Indian companies though? And what he concluded was that Indian companies are still in the pattern of family businesses, right? Wherein we see a concept called majority and minority shareholding. Now, what do we mean by this shareholding structure? If a shareholder is said to have a majority shareholding, whether he as an individual owns those shares or he owns a significant part, his affiliated companies owns other significant part. Whenever you're said to have majority shareholding, it means you have either 50% or and more shareholding, right? And what kind of power would that entail for you? That would entail a direct power during the shareholders resolution meetings for you, right? You have more than 50% of voting share in your hands, right? Minority, on the other hand, have, of course, less than 51% of shares, so they don't have that direct impact on the shareholders meetings resolutions, right? Now, another advantage that you get if you have majority shareholding in a company is you can have your hands over the management of the company, right? So remember an earlier example, in the earlier agency problem we studied, there is a complete separation in the ownership and the management. Herein, because there is a majority shareholding in place, you can have your hands over the management of the company. And why is that? Under Company Law 2013, you need a simple resolution, 51% majority, in order to appoint or remove a board of directors, right? So that power gives the majority shareholding right over appointment of the directors, right? with this recently, and I'm sure all of us would have studied about this matter in the especially in the past 2-3 years, when we had the judgments coming from NCLT first, then NCLT, and finally last year Supreme Court settled down this entire fiasco, right? And that fiasco was really between the Tata group and the Shapoorji Pallonji group, right? Or the Shapoorji group. Now, of course, both of these groups have had familial ties, and they've also had business ties. The Shapoorji group has significant shareholding in the Tata group, right? Now, guys, how Tata group is structured. So you have Tata group comprising of all the Tata companies, right? You have Tata Motors there, you have TIS there, you have all the Tata companies in the Tata group. And who heads this Tata group? So who has the majority shareholding of the Tata group? It is Tata Sons Private Limited, right? Let me quickly go to the chat box. I think we have certain comments there. In Satyam, PwC and company management colluded, fabricating the financial reports. It is the trust who owns Tata Sons. Absolutely correct. So there are two major trusts who have a significant shareholding, I think of somewhere around 60% in Tata Sons. That's absolutely correct. And as far as you pointed out about Satyam, so of course PwC was the auditor in the Satyam case, and they were banned for 2 years for operating in India. So coming back to our case study though. All right, so you have Tata Sons Private Limited having majority of the hold over the Tata group. So now what happened in 2012 was Ratan Tata, he stepped aside as the CEO of Tata Sons, and he appointed Cyrus Mistry, and he appointed him to be really the pioneer of the Tata group now, right? And what happened? So Mr. Mistry was of course appointed to be the CEO of the Tata Sons Private Limited, and hence the Tata Group. And in 2016, in October, a board meeting happened, right? And 9 directors were voting there. And the resolution which was to be passed was, should we remove Mr. Mistry as from the position of CEO, right? And 7 directors voted in favor of 7 directors voted in favor of this resolution that yes, he should be removed from his position. 1 director abstained from voting, and there was only 1 director who voted that no, he should not be removed from the position, and he was Mr. Mistry himself, right? Right after he was removed from this position, Shapoorji Group, the group itself, again, there were 2 companies, and they held, and Cyrus Mistry also held a little bit of shareholding in his own name. Together, Shapoorji Group held 18% shareholding in Tata Sons, right? So now Shapoorji Group, and as you guys pointed out, that the majority shareholding, the 60% shareholding in Tata Sons is owned by Tata Trust, right? Now Shapoorji Group, after this removal of Mr. Mistry, filed a case against the majority shareholders of Tata Sons Limited, which was the Tata Trust. And what kind of allegations were put up? So there was a complete set of 15 to 20 allegations which was put up against these majority shareholders, that there has been dereliction of their duty while acting as majority shareholder. Now, can anybody of you point out how a majority shareholder can act against the interest of a minority shareholder? So my question is, in what scenario can you possibly imagine a scenario where a majority shareholder would actively work against the minority shareholder? Of course, interest of the minority shareholder would be at stake. So let's say if there's a resolution, let's say a merger resolution is there, right? And majority shareholder, of course, they have the majority power. When they'll be present in a shareholder meeting, because of their majority shareholding, that resolution is bound to get passed. Even though minority has objections to make to that merger, or even though that merger might not be that beneficial or actively work against the interest of the minority shareholder, the majority shareholder can still go with the resolution.
10 minutes into it.
Right? And this is how a majority shareholder can actively work against the minority one. So can you guys figure out, if we have to make an analogy here, one party is principal and another one is an agent, whose benefit is at stake at the hands of the other here? So can you guys figure out our second principal-agent relationship which can possibly be there? So one of the arguments put forth by Shapoorji Group here, the minority shareholder here, was our concerns, our voices were not heard by the majority shareholder when they were taking decisions in the shareholders meeting, right? So who do you think in this relationship has the power over the benefits of the other? So the party which works actively for other and can impact the interest of the other is the agent party, right? Your agent can impact the interest of your principal. Principal is the party who has to sit back and who has to let go of their interest into the hands of other party. So in the majority-minority relationship, which party is the principal? Tata Trust is the principal. Absolutely correct. We can say that majority shareholding or majority shareholders should be the principal, and minority no, actually, it's not going to be like that. Let me quickly erase this. All right, I can't erase this somehow. All right, no worries. So guys, in a principal and agent relationship, agent is responsible for benefits of the principal, right? In a majority-minority shareholding group, the minority often says, majority has to look after us. The majority shareholders should make sure that our voices, our concerns, our objections are heard, right? We should get a proper notice whenever there's a shareholder meeting, right? Whatever, if there are any grave objections we have towards a resolution, that should be considered by the majority shareholder group, right? So which party is sitting back here and whose benefits are in the hands of the other party? It is the minority shareholder, right? They're helpless because they don't have that shareholding, that voting power, that say in the ownership of the company and hence in the management of the company. And who has that power over the management, over the ownership of the company? It's the majority shareholder, right? So we say that majority shareholders act as an agent for minority shareholders, and they really have to make sure that interests of minority are not harmed, right? Or they are taken care of. And they don't, majority shareholders have to see that they are not actively working towards the interest of the minority shareholder. Are there any doubts so far? So till now we have established two principles. One of the principle is your owners and management, and another agency relationship is majority shareholder and the minority shareholder, right? In this situation, your minority is the principal and majority is the agent, right? Because minority's interests are in hands of the majority. With this, we move on to the third relationship that we can find out. We can place the analogy of principal and agency between these players, right? And it is company as a whole, so company as the entire entity, and the other players that company interacts with. For instance, your creditors, your customers, your employees. And one of the very good example for this could be the Nirav Modi case, right? So Nirav Modi, of course, looks after, started a business, topped the charts of Forbes magazine, and his business concerned with the diamond jewelries, right? And he used to get his material from Hong Kong, right? And in getting that material, he also took loans from the Hong Kong bank, right? So let's say this is Nirav Modi's company. Now guys, how do you take a loan or a credit from a foreign bank? You have to first go to an Indian bank, and that Indian bank in our case was PNB, right? So if an Indian company has to take a loan from foreign bank, first you'll go to an Indian bank, you'll deposit something called, you'll make a security deposit there, right? Meaning your asset, you'll make a security deposit of your asset with the Indian bank. And in return, the Indian bank would give you a letter of undertaking, right? This letter of undertaking is then sent to the foreign bank, which was the Hong Kong bank in our case. And then once the Hong Kong bank has that LOU, that letter of undertaking from the Indian bank, they give the cash, they transfer the cash to the Indian bank, and the Indian bank transfers the cash to you. Now, I hope you appreciate here that the Indian bank is acting nothing but a guarantor here, right? So if Hong Kong bank or a foreign bank is not able to realize their loans from the individual, who are they going to go, which place are they going to go at? They're going to knock the doors of the Indian bank, right? Now, Nirav Modi was taking constant credit from the Hong Kong bank, right? And these transactions stretched out through years actually. Started from 2011 and went up till 2018, right? And finally in 2018, PNB realized what was going on and they filed a complaint with the CBI. And what did PNB realized? PNB realized that there are two very corrupt officials sitting here who were bribed by Mr. Modi, right? And in the action of bribing those officials, every time Nirav Modi's company would take a letter of undertaking from PNB, there was no security deposit which was given to the PNB, right? So normally what would happen if PNB is acting as a guarantor, and if PNB has to pay back the loan which Nirav Modi's company took, PNB would easily realize it from all the over these course of years that Nirav Modi's company to PNB, right? And how did the company get by without depositing any security deposit? They were simply bribing two officials from PNB, right? Now I want you to keep in mind the actions of this company as a whole. So Nirav Modi's jewelry company, right? Who do you think, so this company's actions, who do you think this company's action is affecting at the end? So which are all the victim parties that comes out of this scam? Or the actions of this company, who do you think really suffers the adverse effects of the actions of this company? We have a few answers in the chat box. PNB, right? So Deep, absolutely correct. So the first and the foremost victim of this entire scam was PNB itself, right? Because the entire liability to pay the loan now falls upon the PNB. All shareholders as well, absolutely correct, because the company itself is suffering at the end of the day. The banks. Can you think of any other party? So what about the employees of the Nirav Modi company, right? Now that the company is going down, what about the employees of the company, right? If there were any customers who were in transaction with the company at the time, when this entire scam saw the day of the light, how were those transactions affected, right? If Nirav Modi's company was in transaction with, let's say, some other companies, how are those companies being affected by all of this? Right? So what we can say is, and public at large as well, because, well, where is PNB going to give its money from, right? So all the government bank, it's the public money which is at stake at the end of the day. So this is how we identify our third and probably the most broadest principal-agent relationship here, right? And when we draw the analogy of principal and agency, and we say our principal is all the other players who might interact with the company, and agent is the company. And why do we say that? Because the interest of all the other players is in the rightful actions of the company, right? The company as an agent has to make sure that there are no adverse impact on interest of the other players. Right? If the company can actively work towards betterment of its creditors, a company can actively work towards betterment of its employees or its customers, right? So this is how we establish our third relationship. So just a quick summary before we end this class. So the three relationships that we identified was, firstly, owners and the management. And in this case, we identified that our owners would be the principal and agents would be the management, right? Our second relationship that we established was the minority shareholders. And we established here that minority shareholding is the principal and their interests are really in the hands of the majority shareholders, so they will be the agents. And thirdly, we established the relationship between the company and all the other stakeholders that company interacts with. And we saw that how company can actively work against the interest of these stakeholders. So these stakeholders would be the principal, and because their interests are in hands of the company, they are the agents. I hope all of you appreciate that in none of these relationships is there an active contract of agency. Right? So even the shareholders and the management, there is no contract of agency between the two. The contract of agency is actually between the company and the director, which we will study in the second leg of this class, an actual principal-agent relationship. Right? These are the analogical relationships that we have identified, that corporate law makers have identified. Right? And we also saw the problems that these relationships can have in terms of all the scams that we just discussed. Now, our second leg of this class would be focused on what are the agency mechanisms that can be put into place in order to firstly rectify if any dereliction has happened, and secondly, in order to prevent such derelictions, right? I would just like to end this class by highlighting as to why agent is prone to making mistakes, right? And the first thing that we see here is there is an information asymmetry. If we take into example our shareholders and management, who has all the key information about the management of the company or the affairs of the company? It's the directors or the managers, right? So they have more information in the picture. You will always find that agent has more information about the actions because it's the agent performing the actions, right? The management making decision. If we see majority and minority shareholding, who gets to have their hands over the management? It's the majority, right? It's the agent who gets to take the key decisions. A very interesting factor is the limits on the earnings, right? And you can clarify this from the first example itself. The management, they have a very fixed earning, either it's salary or it's the fee. So their aim could be to go beyond that fixed earning and to fill in their pockets deep, right? And that forms an incentive to act against the interest of the principal, right? And of course, the last factor is your principal is going to be there for long haul and not the agent. And again, the best way to study this factor is to keep in mind your own and the management. Shareholders are going to be there forever, but your management is going to change, right? So this leads, of course, to a solution that principal are vulnerable to the opportunism of the agent. And in next leg of this class, we will see how we can solve this opportunism or how we can rectify this so that both parties are happy and such scams or such dereliction of duties do not happen. All right, I think with that, we can rest today's class, but I'm happy to hear from all of you. If there are any comments, any questions, any queries that you would like to put forward, I'll be happy to hear all of those. Yes, please go ahead. Yes.
I just want to give a comment and maybe ask, are parents principal of children's actions? Is there a principal and agent construable in a family?
I'm sure if we can draw the analogy of principal and agent in a company, then why not in a parent-child relationship? But what will be interesting to see is who is the agent here. So who is letting go of their interest in the hands of the other party?
The actions of agent, if children are the agents, binds principal, who is the parent, in cases like that, particularly when children are small.
Right.
Subsequently, even if they grow up, ultimately, responsibility of children till the parent dies will always be there with the parent.
Absolutely.
So from that analogy, I would argue that parents can be principals and liable for actions of agents. If agent tries to have extra conflict of interest, that can cause principal also to suffer.
Right. I would agree with this analogy.
Thank you.
Thank you so much. All right, guys. Thank you. If there are no other questions or comments or queries, then let's rest this class. And I hope to see all of you during our course so that we can discuss this topic further. Thank you so much.
Thank you. Bye-bye.
Thank you. Bye-bye.
Thank you, Professor Ruby, for so wonderful talk on the presentation. It would have been more, it was quite engaging. I hope from next time around when the real classes begin, everyone has come read the readings that are provided to you, as well as any other questions regarding the course. We are, it's quite welcome if you want to ask any. I'm there at the help desk. Please feel free to visit and ask any questions. You can drag your character near the help desk by the usage of arrow keys, or you can triple click it on the destination.
Can you hear me?
Yes, sure. We can hear you. Can you please navigate to the help desk? We can address the question.
Is it?
Yeah.
Okay,
yeah.
1 second.
So that is on the left-hand side of the class. Yes, you may just follow me down below. Yes. Yes, you're here. Yes, please tell us.